the company, and whether that petition, whether the person can make a petition and whether it would be, accepted and a winding up process can, be ordered by the tribunal. The court will have to look at the provisions under the Companies Act itself and see whether that amount that has been stated, that is, if the debt is over 1 lakh rupees or not, and then various other factors that we will just see. So I'll go through the provisions that are there and also the various cases that have come up before the various courts where the question has been relating to the payment of debts and the petition that is made to the tribunal for winding up of the company. And once again, remember, till it is notified, all the cases that have also been decided are going to be applicable over here. So it says that subsection 2 of section 272 of Companies Act 2013, it qualifies the requirement of the company to adequacy of the debt. It tells what is that amount. I told you, I specified what that amount is, right? The question that you have to ask is, what is a debt? What do you understand by the term debt? And see whether it is fitting in over here. When you say that there is a debt that is payable, we are referring to a definite sum. It's not an indefinite sum that we are talking about. Am I right? Yes? When I say that there is a debt that is there, you have to give me certain amount of money. I say that you have 2 lakh rupees that you have to give me. It's a definite sum of money that we are talking about. A claim for damages for breach of statutory provisions does not amount to a debt. A debt must be determined sum payable immediately or at a future date. A contingent or conditional liability is not a debt unless the contingency or condition has already happened. If what is contingent? What's the contingency? Yeah, something that is to happen. It may be dependent on some other factors also. So if it's a contingent and conditional liability, it will not be considered to be a debt until and unless that contingency has already happened and which has led to that thing becoming a debt. There is another case where chit fund liability was considered to be a contingent liability. Okay? All of you know the chit funds that are there and the way in which the chit fund activities happen. It depends on whether your name comes in that particular lot. So it's based on a particular contingency. You can't say in the beginning itself that there is a debt that is due. The debt, it becomes a debt when your name has been called and then after that the company has not been able to pay. A company may be a guarantor for the payment of some amount. The principal debtor, if he has defaulted in making the payment, then in that case the guarantor's liability comes. So in this particular case where the principal debtor has defaulted, then in that case you can say that it is a debt that is there on the company. So if 20 lakh rupees was to be paid, or you gave a loan to X for a sum of 20 lakh rupees, XYZ company stood as a guarantee. If you did not pay that amount or someone else did not pay that amount, then automatically it becomes a debt on the company, right? And then in that case you can ask the company for the payment, and you can if the company does not pay, then in that case you can bring up an action. But that takes me back to the discussions that we just had and where you were giving me your answer. I had two people telling me that when there is a debt that is there, when you say that 2 lakh rupees or 20 lakh rupees has to be recovered, you should have asked for that also. It's not just that it's become due. You should have asked that you give a notice and tell the company that 2 lakh rupees is due and please return this particular amount. If the company does not return the amount on the notices that you have served, then indefinitely it becomes a debt, right? But rather than closing down the company, that initiative has to be taken, or that you have to do, to send a notice asking for the amount. But, just coming to it, but it does not mean that it's not a debt. Okay, it is a debt. Yeah, I've answered your questions. Okay. It does not mean, it does not really mean that you should send the notice and only then it becomes a debt. It is a debt, but that initiative or that action you should take rather than ask for the closing down of a company, because closing down the company can affect all those employees who are there who are employed, all those suppliers who are there who are supplying products, all those customers who are there who are purchasing goods from the company. The community and the society at large are stakeholders in the company. So, closing down the company is not the best alternate that is there. Another case where a land development company received money in advance but failed to give plots to purchasers. The purchaser of plots were held to be creditors. So, you've paid, there is a particular company which is developing plots and selling it out to people. They've asked for a certain amount of money to be paid over a period of time possibly. You've paid over the period of time that amount, but that land development company has not given you or not allotted the plot in your favor. It's a debt. The company has been paid but has not given you what it promised under the terms of the transaction or contract that is there. When we look at debts, recovery of debts from the company, there is one particular provision that is there, which I will come to it a little later, which says that whenever a debt has to be recovered and a petition is made and the company is allowing a winding up of the company, there has to be a publication of that in the newspaper. I'll come back to it because we need to understand why this publication is there, but while I'm talking to you about other things, pay attention to what I'm saying, but also keep this thing in your mind, this question in your mind as to why should advertisements be there, how does it, what purpose does it serve, whom does it help, etc. Okay, we'll come back to that question. When we talk about publication of a particular winding up order being published, it may have both economic and social ramifications. The court should look at the interest of the creditors, but it should also look at the public interest that is there. It should not, when a matter is coming before the tribunal should definitely look at the interest of the creditor or creditors. It could have been that one, go back to that problem that I gave you, Ratan or Rajat, whatever the name was, could have made the application, others could have come together and made the application, and maybe the amount could have gone beyond that 1 lakh rupees. The petition would have been acceptable, but the tribunal should just not only look at the creditors, but it should also look at the public at large before it decides whether a winding up should be there or not, or before it gives a winding up order as such. Company code should act with circumspection, care and caution before it says that okay, wind up the company on the grounds that it has not been able to pay the debts to X, Y or Z or X, Y, Z. You need to look at the purpose why you are making a petition also. Why are you making a petition under section 271? Is there a specific reason? Go behind to see what is the purpose of making a petition over here. Go back once again to the question that I had put. Ratan was a director in a company which was a small manufacturing enterprise which did business in the same line as ABC Limited. Could there have been a reason, an ulterior motive of putting a petition, a winding up order? Yes, competition. You wanting to remain in the market, you wanting to eliminate other players who are there, isn't it? So you need to look at why do you want to why is it that somebody has put a petition, when maybe he could have gone to the civil court for the recovery of amount, whether he had other options or not. What is the reason why someone is making an application for winding up of the company? So you need to look at, or you need to go behind, or the court needs to go behind to see what is the purpose why it is done, and the existence of the debt has to be proved. I mean, it's not just telling that 2 lakh rupees is due from XYZ Limited. I have to show with evidence that 2 lakh rupees is payable. Otherwise what happens? I'm tarnishing the name of a company, isn't it? I'm doing everything, and then afterwards eventually the court or the tribunal finds that there's no substance in the petition that is there which was made. So you have to show evidence of the existence of the debt that you are claiming the company has to give you. There must be proof of debt, so you have to show evidences has to be there. I have another case, a 2004 case before you, where the petitioner had taken payment under a private settlement and he made no claim for 4 years. After the settlement, the court said in the first place, this private settlement itself cannot be taken as a debt. It cannot be considered as a debt. And also, it could not be said that the company could not pay the debt. It's not paid, but it does not mean that the company is not in a position to pay. I think Bhavani had put that. Check whether the company is in a position to pay. Like what you said, commercial insolvency of that particular company. You need to look at that rather than saying that the company has not paid, so wind up the company. Is the company in a position to pay? Will the company make the payment of that particular amount? Is there evidence to show that the company will pay the amount? Has not paid, that's one thing, but will pay the amount, because there are numerous instances that are there where a petition has gone, but in the meantime the payment has also been made by the company, right? So you need to also look at this particular aspect over here. Inquiry before admission and advertisement of the petition has to be in terms of Rule 24 and 96 of the Companies Code Rules of 1999. Once again, as I said, till the new rules come, you are still going back to these rules and the provision under section the 1956 Companies Act. There can be an arbitration clause in the contract that is there, but arbitration clause is not a bar on company codes to take up a petition under section under this particular provision. Dividend, all of you know what is the status of a dividend. Company need not pay a dividend, isn't it? We've studied that repeatedly. We've said company need not pay a dividend, but if the company has agreed to pay the dividend and the dividend has been promised, there is a resolution that has been passed by the company, then it becomes a debt. So if there is a resolution passed in the company's shareholders meeting, an annual general meeting, and if the company has not paid the amount which has been declared as dividend, then in that case it can be treated as a debt if it is over the amount of 1 lakh rupees, and you can ask for a winding up of the company. Pre-incorporation debts, on the other hand, they are not to be considered here for winding up of the company, even if like for example the case that I have put, it's an old case, but there was a promise that was there that it will pay. One of the objectives that was there of the agreement was that it is going to pay the amount that was due on a pre-incorporation